From daily list for orders we defect item 8, first appeal file number 9795 of 2024.
Why is it defective?
Last time they had taken time for reply for the IE. That is for.
Have you filed a reply?
No, yes, they have not.
They are not here also.
I have already served the copies. Actually, there are some defects prior to that. Mother has passed a very detailed one, and thereafter some corrections were made in the. And as per the corrections, almost my parties are as per the corrected degree in the memo. So far as 7 and 8 universities, they are not the sons of one Mosman Sadri. For that,
But other side is not here. I can do one thing. Since we have to hear the other side also, so I can just post it tomorrow so that it remains in the supplementary list and it will be taken up. Otherwise, it is down in the list. We cannot assume that they know it, right? Appellant present. Respondent is absent. Post tomorrow. The supplementary cause list. कल supplementary cause list में 2:15 बजे. To be taken up at 2:15 as first case.
Item 9, first appeal file number 1570 of 2026.
Time till 21st August is granted to the appellant to remove the surviving defects painfully. Yeah.
9.
Huh?
9.
So you have to give the court fees, etc.
Yes, sir.
There are other cases also.
Yes, sir.
So what happened to the other cases?
Same.
Same means
Same मतलब सब एक court fees.
आपके पास लिस्ट है?
ये सभी तो नहीं है.
आपका लिस्ट लेके आइए तब ऑर्डर. आपका लिस्ट लेके आइए, ऑर्डर करेंगे, सबको एक साथ टैग करके लगा. ठीक है? At the request of the counsel for the appellant posting, he undertakes to provide a list of all the analogous cases. Yes, a list of all the analogous cases which arise out of the same. तो लवाजिमा वगैरह सबका हो चुका है?
इसमें 7 केस का हो गया है. टोटल 10 केस पाइप होता है. 3 और बाद में 5 होगा.
कोई बात नहीं, सबको टैग करके मतलब
जितना हुआ है उसका लिस्ट.
सारा जितना आप फाइल किए हैं सबका किसी भी स्टेज इट इज इन मीटिंग.
For admission item 1, contempt civil 737 of 2025.
The state deputy is reading that has been approved.
So
Copy has been approved. So for the state part is concerned, that has been complied. उनको दे दिया गया है, यूनिवर्सिटी को भेज दिया गया है. उनको प्रोसेस करना होगा.
एफिडेविट फाइल करिए ना, कहाँ है आपका?
हाँ, yes sir, that's why I am saying ये एफिडेविट रेडी है.
रेडी है तो क्या करें हम
इसको या तो कल तक फाइल करना होगा.
किसका एफिडेविट है?
higher education.
OP number 5.
OP number 4.
OP number 5.
5. Principal Secretary, higher education.
राहुल कुमार पुरवा
Yes.
री नंबर हुआ है, ओपी नंबर 4 है। ओपी नंबर 2 को डिलीट किया गया था
अच्छा।
and opposite parties have renumbered. You filed it
Yes, ma'am.
and now it is pending before whom?
University, they have sent the
University members perhaps is not a party.
approval by the state board that has been sent to the university. Communicate that has been.
Which university? What was the nature of order?
Page 43 for addition पे kindly.
43.
Page 43. The direction was for regularization and for reliefs.
Kolar University board अच्छा है बस.
The responsibility was fixed because of respondent number 2, principal secretary, higher technical.
Okay.
That is because at page number 20 your lordship.
Now they have done the need.
Yes.
We have also done the legal, because I am on behalf of the honorable governor. The regularization approval was to be done by us, so that was done
So
on
you
the
have
last.
done your duty.
That is done.
And
That-
secretary higher education has
that
also
was- yes.
has also done the needful. And university is not a party in this.
It is a party. It's,
Where is that?
it's
They are opposite party number.
there.
They are not opposite parties before the school.
They were respondent
So,
number 5 and
this
6
was
before the
this-
before
As per the read petition, registrar number 3 is the Kolar University. Registrar अच्छा है.
OP numbers 2 and 3.
OP number 2 and 3 are not representing Kolhan University, are they?
No. OSP.
Kolhan University is not there.
Kolhan is the direction was more upon the state and the chancellor, honorable chancellor. Therefore, as per
So since they have already issued the letter, so needful will be done by the university.
may we show one thing, that the showcase that has been received by us today, in that it is mentioned that they have done the pay fixation approval. And then in paragraph 7 of the showcase, they say that the answering opposite party says that subsequent to pay fixation of the petitioner, university has to release the monetary benefit.
That's right.
May I just say one thing, if it is kept pending, because considering is quite low and it may be difficult for the province. The benefits have not been rented, therefore I was paying.
But then the university is not a party university. Then we have to include the university as a party.
We may need for leadership merits.
Because the university was a party university before in the written proceeding.
The learned council for the opposite parties have submitted that needful has already been done by the office of the honorable chancellor and also by the principal secretary, higher technical and skill development department, government of Jharkhand Ranchi. The learned council for the OP number 4 representing the principal secretary has submitted that the required affidavit will be filed latest by tomorrow.
Yes.
The learned council for the opposite parties have submitted that. Now, the further steps is required to be taken by the university for the purposes of making payment to the petitioner. But none of the authority of the university have been made party in the contempt petition. However, they were party in the writ petition.
Yes.
At this, the learned council for the petitioner is permitted to add Registrar Kolhan University Chaibasa, POPS Chaibasa District West Region as opposite party number 5 in the present case and serve 2 copies of the entire records of this case to Dr. Ashok Kumar Singh.
Yes, sir. He was appearing in
To Dr. Ashok Kumar Singh, who was appearing, advocate who was appearing for the university before before the date book. Entire records, right? The Dr. Ashok Kumar Singh, advocate, is directed to seek instructions and file an affidavit in this case with respect to further follow-up action which might have been taken by the university. It is needless to say that admissible amount be credited in the account. Close this case on 14th of August. The affidavit of the registrar of Jharkhand University be filed latest by 11th of August. आज करके पूरा रसीद फाइल और you file it.
For finals was attempt 2, first appeal 154 of 2023.
Writing out of the judgment passed by the on the last occasion which I informed was I have sent the affidavit notes for approval minutes. Because I have received the wakalatnama on behalf of the three respondents who have not filed their who have not entered appearance before this one report. Respondent number 3 and 5, 3, 4 and 5.
3, 4 and 5. You have received wakalatnama.
Yes, Lord. The issue is that the name which is figuring Lord, in the judgment and the decree and was the name by which I have received the wakalatnama because they are different. So I have sent an affidavit Lord, an interlocutory application Lord, seeking for acceptance of wakalatnama. I am praying 2 weeks time Lord, if you be given to me Lord, I will file an interlocutory application by that.
Did you contest this one?
Yes, yes.
3, 4 and 5.
Three and five. 3 and 5. 3 and 5.
What are their names?
3 is Baby Kumar and 5 is Dolly. I have received the wakalatnama of Dolly Kumari by the name of Priyashri C.
Dolly Kumari and
Baby Kumari.
Baby. What is the name of their husband?
Because I have just received the signature because that is why I have called for the entire the Aadhaar card and I have sent an affidavit also to swear whether they are same or not. Along with perhaps the matriculate certificate.
So you must have filed your wakalatnama before the trial court also.
Yes.
Baby Kumari, what is her alias name?
Because as per the instructions below which I have received, her proper name is Priya C.
Priya?
C.
Priya Singh.
Yes. And because for Dolly Kumari it is Priyashri C.
It nowhere finds mention in the.
That is one because I have.
No, even in the records, it is not there. You will have no option but to reject your petition.
Because I have not filed it yet. Because
Yes, whatever you are saying. Who is Prem Sheila Devi?
she is the defendant number 1. She was the wife of the co-sharer of the tablets. And they are the son and daughters of the all of Anil Kumar.
So, defendant number 1 is respond number 1 here.
My lords.
She has entered appearance.
Yes, she has entered.
So this affidavit should be filed by her, identifying them with all details.
It should be that they are the persons who are entering appearance before this honorable court. They are also known by this name and they are the same person and they are the daughters of respondent.
Then we have to edit the cost title with alias name. ऐसा नहीं होगा ना? ऐसा नहीं होगा. Cost title का भी आपको amendment करना पड़ेगा. It is not so simple. Alias name is not so simple. Otherwise, go and seek a declaration from the court. Alias name ऐसे नहीं होगा. कभी तो बेबी कुमारी या कभी तो ये सब नाम कहीं तो आया होगा. कहीं तो आया होगा because while appearing also they are not objecting to it. They are not objecting to that.
I'll get a copy of perhaps of the Wakalatnama which was filed before the learned trial court. The same signature below the
Track report of consignment issued to Dolly Kumari.
That was served to respondent number 3 and 5 loads because perhaps by the ladyship had
Then there is one Priyanka Kumari.
She has, I think, loads entered up here.
Priyanka Kumari has entered. One.
And in the name of, I'm just seeing the lower court records.
Yes.
Even the track report was of Baby Kumari was received.
This even for this
But
one.
where is the Wakalatnama? You get hold of the Wakalatnama.
Yes. I tried.
इसमें तो नहीं है. मेरे ख्याल से वकालतनामा का कॉपी नहीं भेजते क्या है? आना चाहिए ना सब चीज. नहीं. जिनॉलॉजिकल टेबल भी आपने दिया है. जिनॉलॉजिकल टेबल में भी इनका नाम यही है जो आप बता रहे हैं. कोई एलियस नहीं है. हम तो नहीं मानेंगे आपको कोई एलियस नहीं.
Because the Wakalatnama which I have received that just has the signature. So when I was also finalizing because then across the year they were called the concerned
नाम में
person.
काफी फर्क है. वकालतनामा आपको तो मिला है.
One opportunity means what will be given as verified. All them verified no general.
डॉली सिंह एलियस डॉली कुमारी है क्या?
वो तो देखिए in the WS they have mentioned as Dolly Singh and Dolly Kumari. The WS which was filed with them.
That's it. डॉली को लेके इशू है.
डॉली
अभी
को
डॉली
लेके-
का कोई तीसरा नाम भी.
Dolly का दूसरा नाम as per the instructions which I have received was that is Priyasi C.
ऐसा उन्होंने कोई डिस्क्लोजर नहीं किया. दिखाई जरा वकालतनामा जो आपको मिला है.
With the the pencil notes I have written that because I called to take instructions that who the concerned person is.
Signature भी tally नहीं करो.
Notes I have to take. So that is why I'm not filed it yet.
Define.
This is the second one. पेंसिल से जो लिखे हैं वो डॉली सिंह को तो हम लिखे हैं.
वो तो ठीक है आप लिखे हैं पेंसिल को हम देख भी नहीं रहे लेकिन वो प्रियांशु सिंह करके शी साइनिंग
Yes, yes. Because I have to. That
तो
is why I'm
यहाँ
not-
पे she has been signing as Dolly
Dolly
Singh.
Singh. That is why.
I will not accept your वकालत.
That is why I'm not filed it as of now because I cannot until and unless I verify it myself.
Stall नहीं करिए ना proceeding या तो करिए या मत करिए.
One
You
opportunity.
see, being satisfied you accept वकालत, isn't it?
Yes.
That is what you write at the back
But then I
from
have,
the
not,
executant.
I have not filed it as of now.
No, what I'm
My
saying is,
signature is
therefore
also-
your satisfaction
Yes,
is
yes.
prime.
Yes, yes. I do.
Right, unless you are satisfied, don't file it.
That is why I'm not signed. I have not even signed it as of now. It is kept in the file.
Impugn order का हम लोगों ने translation कराया है.
Is in Hindi.
I got it translated, assuming that you will argue today.
The fraud issue is involved in the matter. The learned trial court has gone to the title of the property by deciding the partitions.
That's true.
That title has also been accepted by the defendant, saying that the property belongs to the mother-in-law of the
That's
defendant.
right. Let's see.
Mother of
अब तो ये वकालतनामा में ऐसा फंसा के रखे हैं कि
One,
otherwise we would have proceeded. Why should we wait for?
one indulgence may be given
Yeah,
because I not.
wait for.
Apart from that, because I already have the I've already filed my vakalatnama for the other respondent. Because then,
So that should be sufficient.
yes.
If they are not interested, let them not be interested. So Dolly Singh. Dolly Singh. कहीं नहीं written statement में आया है कि इनका कोई दूसरा तीसरा नाम नहीं.
That I have also verified was is not coming as.
And written statement was filed only by different number 1 and 5. बाकी ने तो नहीं filed. They have not filed it. Counsel for the respondents is adjournment. Next Monday, रख देते हैं. Post on next.
Item 3, the rupees 7423 of 2023.
One after notified or item number 8 and 9, parents for each state.
Answer. Item number.
Item number 8 and 9.
Tomorrow.
ठीक है. कल आएगा कल. Yes, petitioner.
You know, in this case, I filed in IA 978
आइए.
for vacating the stay and for dismissing this petition. For the very fraudulent, my lordship's order, I record 11/5/26 order.
Yes.
Now it records para 5. Council for me submitted that a government school teacher has been treated to be a workman and due order under section 33C of the Dispute Act has been passed. Submitted that you rely upon the judgment passed by the Supreme Court reported in so and so, and then the report to submit that teacher in agency cannot be considered the work. Then para 7 concerning the same dispute involved in this case, the proceeding is being so and so. Pending for the Brazil level court is the state dealing. First of all, these judgments are overruled judgments. Secondly, there is no proceeding.
Which is that judgment which has overruled these
That
judgments?
is both these judgments.
Which is that judgment?
That is Bangalore Water Supply Sewerage.
these judgments
As
have
a
been
constitution,
overruled.
yes, it is the constitution bench judgment.
Show me by which paragraph it has been overruled.
Yes.
Bangalore water supply citation
That is 1978 to SCC.
1978 to
To
SCC
SCC 213. 213.
213.
Yes.
This 19 days, but 1988 judgment.
Yes, 1988 relied on an overall judgment of 66. That's a Delhi. Yes. That is 63 Supreme Court 187 University of Delhi Anal. And this is a 9-judge judgment.
1873. Show me Bengal water supply.
Yes.
Bangalore water supply.
Your option come to page 266, paragraph 101. Our conclusion is that the University of Delhi case Supra was wrongly decided and that education can be and is in its institutional form and industry.
In institutional form.
Yes.
So the teachers are covered
Yes.
by which
The
judgments?
point is that this judgment so far,
Teacher
has
is a
not-
workman according to teacher is a workman.
this is what has been held that it is an industry,
No,
and that is
see, an educational institution can be an industry, but that does not mean that every person working in the educational institution will fall within the definition of workman. There can be menial staff,
that
there
is
can
the
be
area.
so.
That is the area where the Supreme Court is still pending matter.
That's right. That
matter is pending
Bangalore
in the
water
Supreme.
supply has now been referred to a larger bench.
Refer to an argument. That's right.
No, as long as it is not, you see, merely because a case has been referred to a larger bench, that does not mean that a case has been overruled. Right? We are still governed by Bangalore water supply.
Yes, we are still
We
governed
are
by
still
Bangalore.
governed by water. So I
And
just
the
want to
point
know.
of reference is, the point of reference was that the Bengal, this Bangalore water supply doesn't covers that definition, the whether teachers can be involved.
Therefore,
Now that-
Bangalore. Therefore, we want to know that what is the specific terms of reference so far as this Bangalore water supply judgment is
I think
concerned.
refer the-
This is my having the copy.
That is 2005, volume 5, SCC 1. That is UP versus Jayabir.
State of UP versus JB.
Jayabir.
Right. Okay. This is requires consideration by a larger bench, right? So I want to know, is there any judgment of the Supreme Court which says that teachers, specifically dealing with teachers, that teachers would also come within the definition
There
of
is no
workman?
such-
There is no such judgment, right?
One
So,
issue.
to my effort.
yes, which judgment?
We have referred, we have handed over the
1988?
1988 and one in Delhi High Court.
1988, volume 4. Teachers are not workmen, though educational institution they serve is industry. This is 1988, volume 4, SCC 42. This judgment you must have seen. There is another judgment referred in the last order. It is mentioned in the last adjournment order. It is mentioned. In that judgment itself it is mentioned.
No.
In that
This
order,
is the last order, 11/5/2026.
हाँ उस order में ये judgment भी referred है 1988 volume 4 SCC 40
No. 88.
88 4
98 नहीं.
sorry 1988 4
The 88/4, if not to go through that, that was the basis relying upon the 78, 63 Supreme Court. The entire judgment, 88, is based on 63 Supreme Court at Delhi University, which has been overruled.
No, it is mentioned 1963 SC 1873 overruled. It has been mentioned in 1988 volume 4 Supreme Court cases itself.
This is 63. This is 88. See, in Delhi University case, at para 9, it is mentioned
Which Delhi University case?
that 63.
So why are you stuck in 63? You come to
Yes, because
1988
there
volume
they
4.
say teachers. They have mentioned about teachers in that. In paragraph 9, I come to it here. Paragraph 9, it is well known. University of Delhi in most of the educations are not formed or conducted for making profit. No doubt the absence of profit motive would not take the work of any institution outside section 2J, the requirement of the definition. Otherwise satisfied. We have referred to the absence of profit motive only to emphasize the fact that the work undertaken by such educational institution differs from the normal concept of trade or business. Indeed, from a rational point of view, it would be regarded as inappropriate to describe education even as a profession. Education in its true aspect is more a mission and a vocation rather than a profession or trade business. However wide may be the denotation of two or greater words under the Act. That is why we think it would be unreasonable to hold that educational institutions are employees within the meaning of section 2G or that the work teaching carried on by them it is an industry under section 2J. Because essentially the creation of a well-educated, healthy young generation imbued with a rational, progressive outlook on life, which is the sole aim of education, cannot at all be compared or assimilated with that may be described as an industrial process. Therefore, we are satisfied that the University of Delhi and the Miranda College for Women run by it cannot be regarded as carrying on industry under section 2J. So the application made by the respondent against them under section 73, 2 of the Act must be held with incomplete. Therefore, while taking this industry, education into industry, they have
In
taken
any
the
industry,
teaching.
sir, just a minute. In any industry, there are classification of persons who are working, isn't it? In any industry for that matter. You have managerial, you have president, you have secretary. There are so many things in an industry. It is only the workmen who are covered under the Industrial Disputes Act. Similarly, in an educational institution which is imparting education, and as decided in the Bangalore water supply case, that in that the industry, it is an industry, but everybody will not fall within the definition of workman. Principal of a college will not fall within the definition of workman. Teacher of a college will not fall within the definition of workman.
That was the grievance raised before the Supreme Court, and then it was
Sir,
referred to a.
we will hear you. Let us see the petitioner first, and then we will decide whatever you have to say. We will decide. We are hearing it finally. Yes, you start.
We have challenged two orders of the learned tribunal. Petition on page 25.
Yes.
Should I start with page 29 issues?
Yes.
Page 29. that from the pleadings of the parties, following points arise for determination whether the applicant is workman under the Industrial Dispute Act or not, whether the application filed under Section 33 is maintainable or not, whether the applicant is entitled to the amount claimed in the claim application. In order to substantiate this claim, the applicant examined the witnesses, including himself. So far, the first point is concerned the opposite party. White paragraph 4 of show cause stated that the applicant is neither workman as enlisted under Section 25 of Industrial Dispute Act 1947, nor is an industrial establishment under Section 2, subclause 2, clause E of the Payment of Wages Act 1946. As such, the provisions of Industrial Dispute Act 1947 and Payment of Wages Act 1936 are not applicable.
Just a moment. We are only concerned with Industrial Disputes Act, not with Payment of Wages Act, because Payment of Wages Act has a different remedies only.
But he preferred the application for payment of the back.
Maybe for payment of wages, but the question of his application being maintainable arises only when he is covered within the definition of workman as defined under the Industrial Disputes Act. Okay, let us see the discussion.
And coming to last paragraph.
Yes.
In view of Section 2S of the ID Act, a teacher is not workman within meaning of the definition of workman, but in the Bangalore Water Supply and Sewerage Board Limited versus so and so. Honorable Supreme Court has said that the educational institution has to be treated as an industry. This fact may not seem doubt after the decision of Honorable Supreme Court in Bangalore Water Supply and Sewerage Board versus A. Raja practice. There is no agitation for taking
Negation for taking.
negation for taking the view that a teacher is not an workman within the meaning of Section 2S of the ID Act 1947 and the application filed by him before the Labour Court under Section 33C subclause 2 of the said Act is maintainable. So far, this point concerned this court is competent to decide only the dues to the applicant which is capable of being computed in terms of money in which the applicant had existing right. It has been decided under Section 33C subclause 2. The workman under Section S of the ID Act 1947, the applicant submitted that during the course of employment in RC Middle School, Parsa, the applicant was a headmaster and he performed clerical work.
Remaining is all computation. Basically, this is where you are hitting. That workman, teacher cannot be said to be a workman, and therefore, irrespective of the fact that the education institution is an industry.
Actually, this is a general term. This is a general term. Your I have rightly pointed out, and just I just handed over a short notes edition. Short notes. Apart from this MJ case, the petitioner preferred more than 7 to 8 applications before this on record. Under resolution WPS. One of those was W. So when it comes to the taking grade 1, grade 2, grade 3, etc., he outrightly came before this honorable court. When it came to the back wages, he filed MJ case. And
no, you see that conduct may not be relevant because writ jurisdictions are entertained, these are extraordinary jurisdiction, unless any serious objection is raised with respect to the maintainability. Therefore, the writ petitions must have, he was working, the concerned teacher was working where? In which school?
Minority school, having its own rule and regulation 1981 rules.
Oh, under the 1981 Act.
81 rules, having the 1981 rules, they
They
are
aided by the government.
government.
Government aided, and so far as the teacher is concerned, the salary is being reimbursed by the government.
government, and he had resigned in 1996 after
No,
resignation.
we are not on those facts. Important is whether the petition could have been entertained. That is the core issue, and this is where you. And now you place this. Which all judgments do you want to place? You want to place one Delhi High Court judgment?
One Delhi High Court judgment edition and one 1988.
You just place the 1988 judgment
And
first.
there is also a Delhi High Court judgment, very short paragraph 7.
Okay, let us see that.
Last one in my notes.
Yes. Read it, please. Whatever you want to read.
In paragraph 4 also the same issue has been dealt under sub-para 16.
Yes.
Now the question arises as to whether the teacher in the school is a workman or not. The definition of workman as laid down under section 2S of the Industrial Dispute Act clearly takes out the teacher from the purview of definition of workman because a workman does not perform manual, skilled or semi-skilled or technical job. Imparting education is not a profession but a mission. The Honorable Supreme Court has rightly held in case titled Miss A. Sundarman 1988 judgment, which I earlier referred. Now the issue has been decided. Issue number 4. Since the petition was not a workman under 2S of the Industrial Dispute Act, so the provisions contained in Industrial Dispute Act does not come to the rescue of workmen. Accordingly, the termination cannot be looked into under the provision of IDA. This issue is also decided against the workman, thus the termination cannot be regarded with sentence.
Finding starts from para number 6.
The petitioner worked with the responding student and assistant teacher from 1st March 1972 to 1st August 1980. The Education Department, MCD, while considering the respondent's application for recognition of school, raised an objection that the petitioner did not have the qualification for an assistant teacher and was overage, whereupon the petitioner approached the Education Department, MCD, for relaxation of her educational qualification, which was rejected. The respondent raised an objection to the integrity of the claim in the written statement on the ground that the teacher is not a workman within the meaning of section 2S of the Industrial Dispute Act, whereupon the petitioner for the first time raised an objection in the rejoinder that she was doing clerical work. The petitioner deposed in evidence that she was mainly doing clerical work in the school. When the Education Department MCD raised objection to the educational qualification of the petitioner as a teacher, the petitioner never raised this plea that she was not eligible her qualification considered for the post of a color. Even in the statement of claim, the petitioner never raised the plea that she was doing only clerical work. It was only after the objection was raised by the respondent in the written statement, the petitioner set up a new case that she was doing clerical work. If the petitioner was doing clerical work, she would have stated so in her reply to the school and reply to the Education Department, MCD, to seek appointment as a clerk. In her reply dated since such and such, the application dated such and such, the petitioner sought relaxation for the post of assistant teacher and not as a clerk. The petitioner contends that she was doing clerical work is class and hereby rejected.
Now 88.
Tennis. Narrative. The court held that the employee Mukherjee involved in that case was not a workman under section 2S of the Act because he was not mainly employed to do any skilled or unskilled manual or clerical work for hire or reward. which were the only two classes of employees who qualified for being treated as workmen under the definition of expression workmen in the Act.
You are reading which paragraph?
10.
Para 10.
Para 10. The definition of expression workmen in the Act as it stood then. As a result of above decision, in order to give protection regarding security of employment and other benefits to sales representatives, Parliament passed a separate law entitled the Sales Promotion Employee Commission Service Act 1976. It is no doubt true that after the events leading to above decision took place, Section 2S of the Act was amended by including persons doing technical work as well as supervisory work. The question for consideration is whether, even after the inclusion of the all two classes of employee in the definition of the expression workman in the Act, a teacher in a school can be called a workman. We are of the view that the teachers employed by educational institution, whether the said institution are imparting primary, secondary, graduate or postgraduate education, cannot be called workmen within the meaning of Section 2S of the Act. Imparting of education, which is the main function of teachers, cannot be considered as skilled or unskilled manual work or supervisory work or technical work or clerical work. Imparting of education is in the nature of a mission or a noble vocation. A teacher educates children, enhances their character, builds up their personality, and makes them fit to become responsible citizens. Children grow under the care of teachers. The clerical work, if any, they may do, is only incidental to their principal work of teaching. We agree with the reasons given by the High Court for taking the view that teachers cannot be treated as workmen as required in the Act. It is not possible to accept the suggestion that having regard to the object of the Act, all employees in all industries except those falling under the 4F section, the Act should be treated as workmen. The acceptance of this argument will render the words to do any skilled or unskilled manual, supervisory, technical or clerical work meaningless. A liberal construction is suggested would have been possible only in the absence of these words. The decision in May and Becker, India, Universal Workmen, includes us from taking such a view. We therefore hold that the right to right including that
That's so you are relying upon this Delhi High Court judgment, and then you are relying upon this case.
So far, edition, the my refer the Bangalore water supply judgment. It nowhere states that teachers are the workmen. No states. Actually,
you see, the Supreme Court themselves have observed in paragraph number 6 of the judgment in 1988. You read paragraph 6 of 88 judgment.
Thus, it is seen that even though an educational institution has to be treated as in view of the discipline in the Bangalore water supply and several court, the question whether teachers in the education institution can be considered as workmen
still remain to be decided. So the court observed that this was not the issue decided in Bangalore water supply. Bangalore water supply only decided that education institution is an industry. That does not mean that everybody in the education institution would be an industry. The specific issue was decided in this case is that teacher is not a work and therefore not covered under the industry disputes. Right? That is your case? Yes, sir. Respondent? How do you come out of 88 Supreme Court? You just, how do you come out of 88 Supreme Court?
88 Supreme Court, that only observes that the Bangalore water supply, the question whether teachers in a administration can be considered as a still remains to be decided.
And they decided it.
They have relied on and decided it. But the question is that the Bangalore water supply is still pending before the Supreme Court on these matters only. That's why I was looking to that.
About it. Bangalore water supply case only decided whether education institution is an industry or not. And it ultimately decided that it is an industry.
No. Bangalore, it simply did not decide industry. While deciding industry, it has taken into definition of the workman. Now, teacher is nowhere defined under the IDA. What is defined is the workman. Now, kindly see, give me the IDA. That's why I want to impress. Now, what is the definition of the teacher and how the courts have decided? There may be a club functioning also. There are various aspects which have taken into account in the Bangalore Water Supply.
Show me one passage.
Just since it is an invitation, we have to go by the definition because teacher is not defined under the idea. What is defined is the workman. What does the workman say? Any person, including an apprentice, employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward. Now, these are the key words which have been taken into account while deciding which category of a person employed in that industry can be a workman. The entire 88 Supreme Court, which my brother friend has just now said, kindly see, they have taken these words into account to say whether they will come under the definition of workman. And now, who was this respondent number one? He was a headmaster. The question is what job he was performing. He was performing the skill job also. You are taking a supervisory job also. Those are the things to be taken into consideration while deciding whether he comes within the definition of work. Now, in 88 Supreme Court,
can anybody become a principal without being a teacher?
can a teacher only teaches as a headmaster? It doesn't teach. He has to make a supervisory. Overall looking of the administration.
He was working as a teacher or he was working as a principal?
Headmaster.
From where do I
He was
get
a-
this?
That's what
He was
he was
working as a
appointed as.
headmaster?
Can he decide dispute that he was not a headmaster? So that is what was the fact on record. He was appointed directly as a headmaster under the extension improvement program, whatever, that's the government sanctioned post. I am not on that. I am trying to clarify your lordship's question. Whether Bangalore water supply still holds good or not. And for that we have to go through the Bangalore water supply because while deciding industry, the Bangalore water supply has also taken to the definition of workman. And then after holding that Delhi University is overruled, they have decided several other cases, type of workmen working in the industry, and then they have to have elected. I just have to go to 2005 because that is how, to my mind, that is how that was referred to a larger bench, saying that no, this dispute has to be resolved. Because in one case, some may be teacher, in another case, there may be some another employee which may not come under the definition of work. So the whole thing which is pending to be decided is what workmen will take into account. In some case, it may be teacher, in some case, maybe some other, and in some case, it may not be. So this can't be simply harped upon that since 88 they say that that was a question left, but that is to be decided sub judice before the Supreme Court. How can you arrive to a conclusion which is sub judice where all these matters are there?
No, you see that I have heard you. You just place it from the judgment.
Yes, sir.
Place it from the judgment of Bangalore water supply. What was
Yes.
it decided?
Yes.
Yes. What was the issue framed and what was it decided?
No, we will have to go through 2005 ahead.
2005 पहले कि पहले Bangalore water supply?
नहीं, बैंगलोर वाटर सप्लाई को लार्जर बेंच में जो रेफर किया गया है वो 2005 को देखना जरूरी है।
हाँ पढ़ी 2005
बस है।
With the permission of your ladyship, may I submit one thing? It is kindly consider the point of reference. There is nowhere this point, whether that is from the purview of here.
This point of reference in Bangalore water supply.
No, there is.
he will place it, he is reciting it. Let him place it, आप बैठ जाइए. अब हम इनको सुन रहे हैं. Let him say. Yes, please. Sir, आप ही का वेट कर रहे हैं. What do you want to place?
I asked for the judgment.
जब तक हम इनका सबमिशन आपका सबमिशन दिखाते हैं, ही इज वेटिंग फॉर द जज.
One more position. 1996. Compilation. I know 100 hours to revision.
आप दिए हैं 1996. 1996.
SEC 4. 225.
Yes.
I'm referring only two paragraphs.
कहाँ है उसके नाम में?
I'll select this.
Haryana Unrecognized School Association. Yes. Tell me which paragraph?
10 and 11.
Read it, please.
A combined reading of the aforesaid provision as well as the object of the legislation is identical earlier makes it explicitly clear that the state government can add to either part of the schedule any employment where persons are employed for hire or reward to do any work skilled or unskilled, manual or clerical. If the persons employed do not do the work of any skilled or
This is
unskilled,
on Minimum Wages Act.
I
We are not concerned with minimum
I'm just
wages.
connecting up to Article 11. Last one is 11. So it would be clear. Applying the aforesaid dictum of the definition of employee under section 2I of the Act, it may be
Act
held.
is Minimum Wages Act.
There is a dictum. Ratio.
No, this judgment is dealing with Minimum Wages Act.
Teacher would not come within the set definition.
No, this is now dealing with Industrial Disputes Act.
Not relevant. Apart from these legal issues, I want to know that how many cases the prisoner had before.
As a writ petitioner before the court.
It's the issue.
What do you want to say?
Number of, I'm just referring the judgments.
Where is that?
In 2005, that is one. My compilation judgment number one. Here it has been the petitioner is challenging the order dated such and such passed by the BSc Punjab, whereby he has accorded approval of the acceptance of the resignation of the petitioner with effect from
That's
1/6/1995.
1, 2, 3. 2 writ petitions.
1, 2 is WPC number 827, 3 WPL, and all have been dismissed. And presently one petition is pending for hearing before the Honorable Court. All the petitions have been dismissed.
This writ petition has been filed challenging the order dated 19/10/2024 passed in NG case number 5 of 1998. And also miscellaneous case number 22 of 2020 dated 28/7/2023. ये क्या है? Execution case.
2 cases are there. One is in the case of the second one is education. I have challenged.
The learned council submits that the impugn award has been passed by under section 33C2 of Industrial Disputes Act, and the connected case is the execution case. The learned council further submits that the core issue involved in this case is that whether a teacher would fall within the definition of a workman to be covered under Industrial Disputes Act. We have submitted that it is not in dispute that the applicant joined as headmaster of RC Middle School, Ferrari, on EIP vacant post on the metric trained pay scale of rupees 230-340 by appointment letter dated 28/2/1982. And the applicant, namely Yunus Pepita, claimed that certain wages remained unpaid, and consequently she filed a petition under section 33C2 under the Industrial Disputes Act. The jurisdiction of the Labor Court Ranchi was challenged by the management of the school, and ultimately, on the basis of the pleadings of the parties, the following points for determination were framed. Page number 29 का Roman 1 to 3. With respect to the point number 1, the learned labor court held that the petition was maintainable The point was decided in the following manner. 29:30. you don't know page. The Learning Council has relied upon the judgment passed by Honorable Supreme Court reported in within bracket 1988 bracket close 4 SCC 42 within bracket Miss A. Sundarambal versus Government of Goa, Daman and Diu and others, and has referred to paragraph 6 thereof to submit that it has been specifically observed by the Honorable Supreme Court therein that even though an educational institution has to be treated as an industry, in view of the decision in the Bangalore Water Supply and Sewage Board and R. Rajappa, the question whether teachers in an educational institution can be considered as workmen still remained to be decided. He submits that this issue was the point as to whether a teacher would be a workman or not, irrespective of the fact that educational institution is an industry, was ultimately decided by the Honorable Supreme Court in paragraph 10, and it has been, and the Honorable Supreme Court was of the view that the concerned High Court was right in holding that the appellant, who was a teacher, was not a workman, though the school was an industry in view of the definition of workman as it tends to. The Learned Council submits that the aforesaid judgment has been followed by Honorable Delhi High Court in Mandeep Kaur versus Guru Singh Sabha Khalsa, reported in 2019, SSC Online Delhi 10556. Wherein again it has been held that a teacher is not a workman. The Learned Council has also relied upon the judgment passed by the Supreme Court reported in bracket 1996 bracket close 4 SCC 225, and has submitted that the judgment passed in the aforesaid case reported in bracket 1988 SCC 1988 volume 4 SCC 42 has been followed by the Honorable Supreme Court in paragraph 10. And the same principle has been applied to the Minimum Wages Act of 1990. The Learned Council further submits that, so far as the petitioner is concerned, the petitioner has filed numerous writ petitions before this court for claiming service benefits, and appropriate orders were passed from time to time. has also submitted that in the impugned proceedings, the petitioner claimed arrears of salary from 1/3/1989 to 31/1/1993. And also regular salary, which was alleged to be dues of medical leave wages from 1/2/1993 till the date of filing. And the case was allowed. He submits that a writ petition was also filed before this court, being WPL number 675 of 2024, seeking arrears of salary with effect from 1/3/1989 in 4th revised central pay revision with effect from 1/4/1997 in 5th revised central pay revision with statutory penal interest, penal rate at the rate of 18% per annum from the date of its actual payment up to the date of its actual payment. However, the said petition was withdrawn by order dated 17th of May 2020. The learned counsel submits that the learned Labour Court Tranquil lacked the jurisdiction to entertain a petition under section 33(c)(2) filed by the respondent, and therefore the impugned judgment treating the respondent as a workman and entertaining the petition under section 33(c)(2) under Industrial Disputes Act is expedite perverse and cannot be sustained in the eyes. हो गया आपका सबमिशन? इस respondent आपका आ गया जजमेंट?
Kindly come to this Bangalore.
Yes.
First of all, kindly come to paragraph 26.
Para
26.
26.
A panoramic view of the statute and its jurisprudential bearing has been projected there, and the essential of an industry decoded. The definition of employee, section 2G, industry, section 2G, industrial dispute, 2K, workman, section 2S, are a statutory dictionary, not popular parlance. It is plain that merely because the employer is a government department or a local body, authorized statutory body, society, or like entity, the enterprise does not cease to be an industry. Likewise, what is the common man does not consider industry need not necessarily stand excluded from the statutory concept. Now, so after taking the panoramic view of the Industrial Act, kindly come to paragraph 93. We dissent with utmost difference from these propositions and are inclined to hold that the corporation of Nagpur Supra held that education is the industry, and Isaac held in Australian case that education is eminently service. The actual decision in University of Delhi was supported by another ground, namely that the predominant activity of the university was teaching, and since teachers did not come within the purview of the Act, only the industrial activity of the secondary staff could fall within this scope, but that could not alter the predominant character of the institution. So that was how the Delhi University took into account the not only the predominant function of education, but since teacher is also did some. We may deal with this contention in a brief way since the substantial ground on which we reject the reasoning have already been set out elaborately. So these reasonings were taken into account in the Delhi University and that was rejected. And now, para 101, after dealing with all, our conclusion is that the University of Delhi was wrongly decided and that education can be and is in its institutional form and industry. So what the 9 judges have held, they have examined elaborately the Delhi University judgment, taking into account the educational function and the teachers teaching in the account and other incidental work. So everything as a whole has been decided to be negated, the argument in the Delhi University, and that it has been overruled as a whole. The judgment has not been ruled overall in piecemeal, and therefore any subsequent judgment, considering that the judgment in the Bangalore supply was limited to only industry, to my mind, that is not proper. Until unless this Bangalore water supply.
So do you want to say that the observation of the Honorable Supreme Court in paragraph 6 was not proper?
Yes, because this is a 9 judges judgment. You have held, but I have shown you from the judgment how the 9 judges have explained themselves while taking the Delhi University as a whole the judgment. And that's why para 24 when I read, it was a panoramic view of the industrial dispute act, all provisions. Then they have discussed the Delhi University judgment in a thread-bearing manner on these points, and then they have held that it is overruled as a whole. It is not a pre-dispute. This is what I refer to from this 9 judges. Now,
Just a moment. We read para 96 also.
para
96.
yes, 96. Secondly, there are a number of other activities of the university administration, demonstrably industrial, which are severable, although ancillary to the main cultural enterprise. For instance, industry may have a large printing press as a separate but considerable stand. It may have a large fleet of transport buses with an army of running staff. It may have a tremendous administrative strength of officers and clerical cadres. It may have कर्मचारीज of various youth. As the corporation of Nagaur has effectively ruled, these operations viewed in severalty or collectively may be treated as industry. It would be strange indeed if the university has 15 transport buses, hiring drivers, conductor, cleaner, workshop technicians. How are they to be denied the benefit they have, especially when their work is separable from academic teaching merely because the buses are owned by the same corporate personality? We find with all defense little force in this process of nullification of the industry character of the city multiform. Therefore, they have taken a wholesome meaning in the definition of workman as under 2S.
Read para 95 also.
We may deal with this contention in a brief way, since the substantial ground on which we reject the reasoning have already been set out elaborate. The premise relied on is that the bulk of the employees in the university is the teaching power. Teachers are not workmen and cannot raise dispute under the Act. The subordinate staff being only a minor category of insignificant numbers, the institution must be excluded going by the predominant character test. It is one thing to say that an institution is an industry, is not an industry. It is altogether another thing to say that a large number of the employees are not workmen and cannot therefore avail of the benefits of the act, and so the institution ceases to be necessary. The test is not the predominant number of employees entitled to enjoy the benefits of the act. The true test is the predominant nature of the activities. In this case, the university or an educational institution, the nature of the activity is hypothesis education, which is a service to the public. Ergo, the university is an industry. The error has crept in, if we may so with great respect, in mixing up the numerical strength of the personnel with the nature of the activity. So if we read 95, 96, 97, 101, what the Supreme Court 9 judges said that we have to take it as a whole. We can't segregate it on the basis of
There is
something.
no doubt that education institution has an industry. That does not mean that everybody working in the educational institution will become a workman.
I am trying to clarify.
Every industry has number of classifications. Some are managerial, some are supervisors, some are, but everybody does not form a part of the work.
I am trying to clarify the question that you have lordships have posed. That how Delhi University has been overlooked and this has not been considered. Teacher part was not considered. That is what I am saying.
I have seen this.
Yes.
You have relied upon paragraph 93 to 101.
What? Read with 24, which I have said, which says that the Delhi University has completely. So that's the sole contention.
That's
which I have to say. Now, so coming to the
that
fact of the case.
no, you have to distinguish 88 also. 88 Supreme.
That is what I said. 88.
So that particular
88,
paragraph 6 is of no consequence.
According to me,
recorded.
until and unless that part 93 to 101 is not overruled considering the Delhi University, I think that will have not much bearing on this constitutional decision. Once the whole judgment has been overruled, to hold that this has been not decided in the, well, it can only be said by a larger.
No, they have not relied upon this 63 judgment. 88 judgment is not relying upon 63 judgment at all. No. And where is the reliance? There is no such reliance.
No, I am saying on para 6.
Yes, para 6.
Para 6, what they say.
The Supreme Court had no jurisdiction to comment upon what was decided in Bangalore supply.
Yes, which is still to be before a larger bench. That is to be larger bench to say. What is decided, what is not decided. There are, your lordship will get several judgments in which they have said that the Bangalore water supply did not touch this point. But that was the point which was raised in 2005. And then that was referred to a larger bench because that was giving a lot of confusion.
You were relying upon this 2005.
No, that was the judgment by which it has been referred to a larger bench.
You want to rely upon this or you don't?
No, I don't want to. I would just want to say that the confusion which is going on by various courts, that was the necessity for referring it because the line judges.
What is the terms of reference to the larger bench?
In the last paragraph. 45. We do not consider necessary to say anything more than give it to the larger bench to give such meaning and effect to the definition clause in the present context with the experience of all these years and keeping in view the amended definition of industry kept dormant for long 23 years. Pressing demands of the competing sectors of employers and employees and the helplessness of the legislature and the executive in bringing into force the Amendment Act compelled us to make this reference. Let the case be now placed before all the justices. This is how.
Normally, there has to be a terms of reference, isn't it?
This is what they do. They have referred to various judgments of the high courts, their different interpretation of an industry on various accounts, and therefore, and then there was an amendment brought in by the parliament, and therefore they said that since this definition and the ruling has remained for 23 years, how it has to be taken in view of the amended provisions.
Industry, the definition of industry was
Industry,
amended, making it restrictive, or it is making
No.
it wider?
no,
What was the amendment brought in? Definition of industry?
no, now reading in the book and then referring it to also, I will have to also go through the entire judgment. But this was only for a short point that is pending before the other. I'll go through it and I'll refer to it also.
Yes. And what else do you
And
want
now,
to say?
fact, the fact is this, first of all, the writ petition has been filed after 19 years, when the judgment has been given effect to, and there is no MJ case pending, no exclusion case pending. So ultimately, it is an academic discussion, that's all. And also will kindly come into fact that they have filed this writ petition against the order dated 1910-2004, passed in MJ 5 2000. That is almost 19 years. And their earlier writ they had filed against the same order, that is WPL number 4560/2006. That is annexure AY1 to my IA. The earlier on 14/12, nobody appeared on behalf of petitioner, and the case was called out. The prayer made on behalf of the council. This case was adjourned for 2 weeks. Also, again on 4/8/10, this was adjourned on 6/8, and even today nobody appears on behalf of the petitioner. According to this is the law. This was on 6/8/2010, and after 13 years of this order, this writ petition. Now, if you see the prayer of the writ petition,
I don't find it, which is the execution for seeking interim stay. You have filed an application for vacating the stay.
yes. IN 9786 of 26.
Have you disclosed it in your writ petition?
Kindly turn to their paragraph where they have said. Kindly two. Kindly read this paragraph.
They have disclosed or not disclosed?
Yes, they have written that they had filed a writ petition WPL which was disposed of by the honorable. They have not given the date. They have not annexed the order.
It was dismissed for non-prosecution.
Yes, they did not press it. And then after 13 years from that date,
Nobody had appeared, and ultimately they have
yes,
the
after-
writ petition was dismissed.
and
Just
and this writ petition they have asked for was the order passed by learned presiding officer, Labor Court Ranchi MJ 598 dated 1910 and exclusion miscellaneous case 22 of 2020 dated 28/7/2020. Those proceedings are not pending. They have already been this
that
the
has been
point.
executed. Execution is over.
No, that is pending in before the collector.
That's right. So that is pending. It is recovery is pending. It is a certificate proceeding. That
Yes,
is C2, it
yes,
is a
that is
certificate
pending.
proceeding.
That is
So that is pending. The amount is yet to be recovered.
Let's very short point.
Yes.
Rightly, my learned senior friend pointed out that in the execution proceeding, the learned presiding officer condoned the delay of 17 years, while holding that he does not have the jurisdiction to entertain this.
Oh, let me clarify your question. That was
It has
another
been
thing.
condoned.
No. That
They were
was
condoned
Condoned.
in the execution case.
In execution case, actually the order was in 2006, 2004, and they filed execution application in 2020. After adopting all these process before this
20 क्या हुआ?
2020.
20.
Yes. After adopting all the process available before this honorable court, one lead, second, third one, when he died, then he preferred execution case.
So execution became time back.
kind. And you come to Lord this order of the execution. At page 34. And you see what has happened.
At page
This is the order is 34. At page 34. And you will also come to paragraph 18 of it. Section 33(4) of the IDF provides that the decision of the labor court shall be forwarded to appropriate government and any amount found due by labor court may be recovered in the manner provided subsection 1 of the IDF. I find that no period of sending the award has been prescribed under subsection 4 of the Act, and there is no evidence on the case record to show that in view of section 33(c)(4) of the IDF, order dated Itna pass in MG case was forwarded to the AP government. Therefore, in view of this court, it will be approved to forward the same to the approved. In view of the above, I find that this court has no jurisdiction to entertain the applicant filed under section 33(3), and the present case is not maintainable of this court. Further, copy of the order dated Itna pass in MG is being forwarded to the applicant under 33(c)(4). They are at liberty to appear and file application immediately required. So this exclusive case was held to be not maintainable because it was for the labor court, the award court to send it to the applicant government.
So then what happened?
Nothing. This exclusion ended here. It held not maintainable and he sent the record to the government. And the government is sitting tight over it.
The noticeman can be allowed to refer para 15 of that judgment. What my learners friend refer of execution case, para 15. The appropriate government, in terms of provision made under section 33(c)(1) of the Act, is empowered to execute the award order. Further, in case of breach of any terms, any settlement or award, the appropriate government in view of 34 of the Act.
You see, execution case cannot be filed before the court. It has to be filed through the government before the executing authority, which is to be executed as a certificate proceeding. Has any certificate proceeding been initiated?
Now it has been instituted.
Now means this, you have challenged this order also. This order is all under challenge. Why have you challenged when it has been held that the execution case before the court is not maintained?
Legislature was time barred. Section
No, it was time barred means the court itself says that it is not maintainable.
33(c)(1). After 1 year, the court has condoned the delay.
No, I am not saying this. I am saying that this particular case, right, this execution case order, you have challenged. But it has been held that it is not maintainable, still you have challenged it. Why? The execution proceeding is said to be not maintainable. Did you challenge this order? You have also not challenged it. They have also not.
It's a correct position. It is not maintainable.
Have you filed any execution case?
This was the execution case. Which they have
Apart
dismissed.
from this, have you
No.
have you received any payment for the
No.
period? इसका पेमेंट मिल गया कि नहीं मिल गया कि ऐसे ही लड़ रहे हैं बिना
अगर
काम
आपको पेमेंट नहीं मिला है वो तो आप यहाँ एडवोकेट क्लर्क का काम कर रहे हैं पेमेंट नहीं मिला है
पेमेंट नहीं मिला है तो एग्जीक्यूशन खत्म हो गया है तब इनके पास क्या रेमेडी
तो गवर्नमेंट के पास पेंडिंग है ये तो गवर्नमेंट को भेज दिए रिकॉर्ड अब रिकॉर्ड से वो गवर्नमेंट इनिशिएट करेगा I just asking you, any certificate proceeding has been initiated by the government. So now it is to go by the government will, Labour Department will initiate.
The petitioner ought to have approached the Jharkhand Education Tribunal. एक ये भी ऑर्डर हुआ है.
अरे उसको उसको डिसाइड कर दिया कि वो झारखंड एजुकेशन ट्रिब्यूनल जब कंस्टिट्यूट उसके पहले का ही मैटर रेट्रोस्पेक्टिव इफेक्ट नहीं दिया सर.
Procedural है सर. It is only procedural. So retrospective की कोई बात नहीं है.
ट्रिब्यूनल जो झारखंड एजुकेशन ट्रिब्यूनल वो 2004 में साइन किया. ये पहले का मैटर इसलिए वो कवर नहीं.
कोर्ट तो होल्ड कर दिया है कि पीछे से कवर.
नहीं उसके बाद ये फिर होल्ड हुआ है.
सर हमको लगता है इन्होंने भी मूव किया है झारखंड एजुकेशन ट्राइब्यूनल.
After that interpretive application, we verified then several lists were found filed. Even one has been decision by your leadership in WPM. Withdrawn.
That was withdrawn.
Yes, leadership. And earlier one was 2005, 2009, 2017.
How can the respondent reply to all these facts? It is not on record.
Actually,
At least they should bring it on record to reply us.
they have mostly they have he has preferred WPS, Writ Petition Service. If he was the workman, he must have filed WPL.
Anyways,
Must have
the
filed
writ
that
petition was entertained and the order was passed. That WPL which you are referring, sir, was filed by the state of Jharkhand.
Which one?
That which was dismissed as not pressed.
They are state of Jharkhand.
You are state of Jharkhand.
They have filed their WPL. That's why I was saying. One after 19 years and the other is after 30 years. This WPL is by state of Jharkhand.
What do you have to say to this? You filed your writ petition earlier that was dismissed as not pressed, and you file a fresh writ petition. Yes.
What is present with that all those cases, other writ petitions, the state continue to fight.
And
How-
there is no
how will the state-
explanation in the entire
How will
WPL.
the state file a fresh writ petition? Yes. How will the state file a fresh writ petition?
For challenging the execution, since I have to challenge the execution case.
Execution case, there is no execution case pending. That was held to be not maintainable. So,
And your lawsuits in your order have said that this execution case is pending on their SS paragraph 7 of your lawsuit last one. 11/5/26 order.
they have said whatever they have said, we have recorded.
Yes, yes. And it was already decided on 28/7/23.
The learned counsel for the respondent has opposed the prayer for bail. Sorry, the bail
यही होता है. फर्स्ट हाफ में बेल सुन रहे हैं, सेकंड हाफ में आप रीड सुनिएगा. हम लोग को तो बहुत दिक्कत होता है.
The learned
But
counsel
once
for
you have got grip of the bail now.
I don't know. काउंसिल को शांति से सुनिए तो कोई भी सब्जेक्ट समझ आता है. The learned counsel for the respondent has opposed the prayer
मैं ठीक हूँ.
and has submitted that the petitioner had moved this court earlier in WPA number 4560 of 2006, which was dismissed as not pressed by the order dated 6/8/2010, and thereafter they have filed a fresh writ petition on 19/12/2023, challenging the same order and also challenging the order passed in the execution case. Although the execution case itself was held to be not maintained. And therefore, the petitioner cannot have any grievance with respect to the order passed in the execution case. The learned counsel has then submitted that so far as the merit of the case is concerned, he has placed the judgment passed by Honorable Supreme Court, reported in bracket 1978 bracket 2 SCC 213 Bangalore Water Supply and Sewage Board versus A. Rajappa and others, and has referred to paragraph 26 of the judgment to submit that the Honorable Supreme Court has crystallized the paranomic view of the statute and its jurisprudential bearing, and the findings have been recorded by paragraph 93 to 101, and ultimately in paragraph number 101, the court concluded that the judgment passed in the case of University of Delhi, which was reported in 1963, Supreme Court has been held to be wrongly decided. Paragraph 24 and 93 to 101 of the aforesaid judgment is quoted as under. The learned counsel has then referred to the order of the Honorable Supreme Court reported in bracket 2005 bracket 5 SCC 1 State of UP versus Delhi Singh, and has submitted that the judgment passed in the case of Bangalore Water Supply and Sewage Board versus A. Rajappa Supra has now been referred to a larger bench. The learned counsel submits that once the educational institution has been held to be an industry within the meaning of section 2 within bracket J of Industrial Disputes Act, there can be no reason to exclude the teachers from the purview of the said act. He has then referred to the judgment passed by Honorable Supreme Court for 63 wala citation लिखिएगा AIR 1963 SC 187. The Honorable Supreme Court reported in bracket 1988 bracket close 4 SC 42, and has submitted that the observation of the Honorable Supreme Court in paragraph 6 of the said judgment was completely out of context. Once it was already decided by the Honorable Supreme Court in Bangalore water supply case that educational institution is an industry and submits that in their foresaid background, the judgment passed by Honorable Supreme Court reported in bracket 1988 bracket close 4 SCC 42 may not be denied. That's all.
Actually, one instruction was actually the petitioner has preferred certificate case before the certificate officer. Instruction.
Where do you see this?
I saw the instruction through message from concerned officer.
What
So-
is the case number?
That is not be provided, but this I received from the officer concerned.
Fresh certificate case.
Certificate case. Number two, actually, while seeing leadership, I'm just trying to refer the judgment which my petitioner tried to refer. It was not decided on merit. Simply it was dismissed not based.
The learned counsel for the petition in response has submitted that earlier the petition was never decided on merits. It was simply dismissed as not best, as nobody had appeared before the court to pursue the case. Since the case was not decided on merits, therefore the fresh petition is not barred. He submits that the cause of action still survives inasmuch as the amount which has been quantified under section 33(c)(2) is realizable through a certificate proceeding, and he has received instruction that the certificate proceeding has been instituted by the respondent for realization of matters, and the matter is not closed.
This is not on recording.
To this, the counsel for the respondent has submitted that the fact about filing of a fresh certificate proceeding by the respondent has not been placed on record by way of an act. That's it. Yes, sir.
From notify this for judgment item 1, first appeal 166 of 2009, along with item 2 and 3.
These appeals are allowed.
From daily item 4, first appeal. First appeal 237 of 2024.
Must have been playing for not today.
I am representing on behalf of respondent number 1, 3, 4, and 5 and 7. Your Lordship, my senior sister in Paris hospital, and he will not able to implement it. Kindly fix the matter.
After
She is in serious.
and how about you?
My senior, I'm playing for not today. My senior is gone. He has left the court premises. He had some medical emergency.
No place to live in. Just go to the hospital.
Yeah, his son is not well. He had to leave. Around 2:30 he had to leave.
Both the learned counsels are simply adjourned on the ground of one or the other medical emergency in their family, in their respective family. when do you want? Where is the short synopsis and list of dates and all these things? Where do you find it? You give it to me right now. Where is it? How about you? Where is the short synopsis and list of dates?
He has already submitted his submission.
Already submitted. Is there anything? When did you submit? When did you submit?
I didn't write.
Sorry?
I didn't write about this my senior in this.
Don't file it. I will not accept it. Okay? You are debarred from filing it. And you want to file it or you don't want to? I will no, not now. If you file it just now, it is okay. Otherwise, you are also debarred from filing it. I don't need written submissions. Why should I? I don't need written submissions to decide a case. If you have not filed it, I will depart with some.
Ma'am, give the copy of synopsis.
You have a copy of the synopsis. You submit it right now. If you are able to submit it, you file it right away. अभी हमको चाहिए. फ्री स्टाइल में आगे करिएगा, फ्री स्टाइल में ऑर्डर दिए. जैसा स्टाइल में बहस करिएगा वैसा ही स्टाइल में ऑर्डर. The synopsis. कितना साल हो गया प्रैक्टिस करते?
Ma'am, 8 months.
ये अपीलान का सिनॉप्सिस बोल रहे हैं कि आपका रिटर्न नोट्स का काम है. फर्स्ट ईयर में चले जाइए. क्लास फर्स्ट ईयर कॉलेज के दिन लायक नहीं है. What do you mean you don't have any idea? तो क्यों बोले कि ये है फाइल कर देते हैं? देखिए ना, है ना? In spite of order dated 6th of July 2026, the learned counsel for the parties, वापस कर दीजिए, have not prepared, not filed their short synopsis, list of dates, and the copies of the judgment which is to rely upon. And they were directed to do so much prior to the next date of hearing. It was fixed on 13th of July 2026, by order dated 6th July 2026. Since they have not complied with the order contained in paragraph 6, their synopsis, etc., will not be accepted, and they are free to advance their arguments on the basis of materials. अब आपको मेहनत करने की जरूरत है. बताइए कब करना है? आपको कब करना है?
Senior.
As both the parties are seeking adjournment, pose this case on 23rd of December. Around 23rd December को कर देगा. ठीक है? इस साल करें कि दो तीन साल बाद रख लो? ये फाइनल डिस्पोजल है ना ये मैटर, and put up this case in usual course. अब आपके 10 साल बाद ये केस, after 10 years. चलिए discuss करते हैं.
Item 5, WPL 2847 of 2024.
Yes.
Short point is involved in this case also. Only the petitioner is entitled for interest or not also. This is the case.
Interest on?
Of as per the section 7 3A of Gratuity Act.
Why will you not be entitled to interest? It is a statutory interest.
The petitioner retired on 31st 12/2015 and
31/12/15.
And after 6 months, they have not given after 30 days or so after retirement, they have not given gratuity or so, which is mandatory provision as per section 7. Thereafter, when they have not granted gratuity to me, we have moved before the court, labor court, on after 6 months of my retirement.
You move the labor court or you move the authority?
Sorry, my authority. I'm sorry, authority. For my gratuity also. Then the authority has decided due to prayer which has been made in the petition that whether the gratuity has to pay by the under cement wages or the gratuity act. This issue, and due to this issue they have said that no, you are not entitled for the interest. During pendency only.
Is there a separate provision for gratuity under the cement wages act?
No separate.
It is only one payment of gratuity?
Yes, your lordship. That is my case only and covered by your lordship judgment.
No also judgment.
Yes.
These are all statutory judgments.
Yes.
26 दिन और 30 दिन वाला.
30 दिन.
बस उतना ही तो.
बस इतना ही है हमको. ग्रेजुटी हमको मिल गया, इंटरेस्ट हमको चाहिए.
इनको दे दिए हैं जजमेंट. ले नोट कर लीजिए. WPL 2120 of 23. इसका जरा देखिए हम लोग का WPL 2120 of 23 dated 10/12/24. Did they deposit the gratuity amount in the court?
They have granted 2,22,342 rupees they have given.
So given when? Or deposited in the court?
That has to.
See, एक बार deposit कर देने के बाद interest बंद हो जाता है.
That I have to ask. Thereafter I have filed appeal in it.
That's right. Might have.
When
When did they deposit the amount?
May fix this case tomorrow. So I will ask the claim.
Not tomorrow, but any other day. After tomorrow.
After tomorrow, no holiday. इसका तो LPA हुआ. Check करिए. WPL 2120 of 23.
LPA तो कोई दिखा नहीं रहा.
The hearing of this case has commenced. The admit case है.
ये final disposal में.
As the court time is over, close this case for further hearing. Person will report to the case. उसके बाद next Monday I think.
Today's list was alternate.